Hello, everyone. My name is Arshu John. I am the Political Editor at Polis Project, and we have with us today Balakrishnan Rajagopal, who is the Associate Professor of Law and Development at the Department of Urban Studies and Planning at MIT, and the Special Rapporteur on the Right to Adequate Housing with the UN. Thank you very much, Mr. Rajagopal, for your time, and welcome to our podcast. Today, I'd like to speak with you broadly on the topic of punitive demolitions and your work as a special rapporteur with respect to India and more broadly internationally as well. If, to start off on a slightly broader note, if I could ask you to briefly sort of explain your mandate, your scope of powers, and the tools at your disposal as special rapporteur.
UN special rapporteurs are independent experts who are appointed by the UN Human Rights Council in Geneva. The UN Human Rights Council is a body under the UN Charter consisting of member states, and the UN experts were appointed or appointed for their competence, for their special knowledge, and for their independence. We are not UN employees. We are not paid by the United Nations, and we retain our own original jobs. In my case, I continue to be a professor at MIT. The appointments are usually for 3 years, followed by another 3 years, a total term of 6 years. And the responsibilities of the special rapporteurs are several, one of which is the submission of periodic reports. In my case, one report each year to the UN General Assembly and one report to the UN Human Rights Council. And the other responsibility that I have as a special rapporteur is to make country visits, which are in depth country assessments that are carried out after an officially agreed upon visit with a country in question. And they result in evaluation reports of those countries, which are submitted to the UN Human Rights Council as well. The third responsibility that I have is that I receive a lot of complaints from individuals and communities who are affected by the violations of their rights around the world. In my case, the right to adequate housing. So, for example, people whose homes are demolished or who are forcibly evicted or who are discriminated against in accessing housing, they all reach out to me. So it's an accountability mechanism. When all else fails nationally, you do have an international mechanism where you can complain to. So it's a very important safeguard at the global level. The other last thing I would say is that a UN special rapporteur, when he or she is appointed to deal with a particular human rights issue, is also usually considered the global focal point on that issue across the UN system. So any topic or dialogue or any sort of report or other things that are generated on which a particular issue arises that involves the human rights in question, in my case, the right to adequate housing, usually my input is sought. So the Secretary General, for example, issued a report on homelessness, and I was able to have an input into that as a member of the technical advisory committee for the report. So those are the kind of broadly the work that we do. Rapporteurs are not behind the scenes experts. We are up and front. We are public figures. We are in the media all the time, and we do advocacy actively. So that's in a nutshell is what special rapporteurs do.
All right, thank you very much. And through the course of this interview, I do want to touch upon different aspects of the things that you've talked about. What I want to start with is recently in India, in the Supreme Court case pending about the spate of illegal demolitions that we've had in the country in recent years, you filed an intervention application. In that application, you mentioned that punitive demolitions constitute an aggravated form of human rights violation. In your mind, what is a punitive demolition, and is this a term that's recognized in international law?
Well, in my intervention, as I point out before the Supreme Court, which I must say I found it unfortunate that there was a decision not to formally admit the petition, but still the petition is public and everyone has seen it, and we will also be posting it on the UN website. So the evaluation by the UN expert is quite clear about what's going on. Whether or not the court takes that into account is up to the Indian courts. Um, but as far as demolitions are concerned, as I say in my intervention, demolitions are per se not illegal as long as demolitions follow the standards laid out by international human rights law. But having said that, demolitions that don't conform to those requirements under international human rights law are arbitrary demolitions and therefore not consistent with international human rights law. Demolitions should not be arbitrary. And the word arbitrary has a specific legal meaning, both under international law, but also under Indian constitutional law. I mean, because as a graduate and a lawyer from India myself, I know quite well how Indian courts have interpreted that provision, including the concept of reasonableness, stretching back all the way to the Maneka Gandhi case. So it's an issue we have to be clear about, that demolitions, whether or not they are punitive, can still be arbitrary. And when they're arbitrary, they're wrong. They're contrary to law. But the punitive demolition goes one step further because they are not just arbitrary, but they are also carried out as a punishment against individuals, particularly as I have seen over the last few years, against individuals who belong to particular religious groups, in this case, Muslims, as a punishment for an alleged crime or involvement in some other activity that is deemed objectionable, and usually without any legal procedure of any sort. Homes are demolished. This form of punitive demolition is simply an aggravated form of human rights violation, as I said in my intervention before the court. There is simply zero legal basis for such demolitions. They're simply illegal acts. They're no different from a mob descending on your house and demolishing it. So the state might send its agents, but the state here is completely acting outside the bounds of law. So I'm really glad that this case is being heard before the Supreme Court, and I have every reason to hope that the Supreme Court will consider this matter very carefully and then issue appropriate orders to bring this practice to an end, and then to also control the wider problem of arbitrary demolitions. There are many demolitions that are happening all over India, but some demolitions are aggravated forms in the form of punitive demolitions. They must be stopped, but the arbitrary demolitions themselves need to be brought under control. So the issue of demolitions goes beyond simply targeted demolitions against particular minorities.
Like you say, not all demolitions are necessarily illegal per se, as long as they follow the international human rights law standard. And even within India, we do have different sort of guidelines for a notice period or an opportunity to be heard, all those things. So, as the Indian law stands right now, or the legal position, does that comply with the international human rights standard, or does it fall short?
My sense is that demolition orders, particularly those that are not carried out as a result of land acquisition under the 2013 Land Acquisition Act in India, they are often quite arbitrary. They are not based on proper legal processes. The notice periods are often extremely variable across jurisdictions, and the notices periods are not strictly complied with. And the form in which the notice is issued is often deficient, including the language in which it is issued. The right of people to have access to legal aid is often not mentioned on these notices, so people are unaware of it, or they have no access to such legal aid to contest the decisions. The actual process of demolitions are often deficient in legal terms. For example, they're often carried out during the night or during times of the day when it'll be very difficult, or the times of the year when it'll be very difficult for people to adjust. For example, during rainy season or monsoon season, or during very, very hot summers, or demolitions of homes where families with small children or older persons who have disabilities are living. Those issues are not properly considered. In other words, there is not really a requirement under Indian law anywhere to do a pre demolition social impact assessment. There is no assessment if you're going to demolish a home about what the impact of the demolition would be on that family. And an approach that is consistent with the international human rights law would actually require that. Unfortunately, those requirements are missing, and I list a number of those elements in my intervention before the Supreme Court, and I've suggested that they take those suggestions into account, because there is a procedural, lacuna when it comes to what sort of notices should be issued, for how long, and what assistance should be given, and all the rest of it. But there is also the substantive issue of the proper grounds on which a decision to demolish an entire home should be taken. So, in that, for example, often we are told that homes are demolished because they are contrary to building standards, or some part of it is not in compliance with building codes. Now, this is actually a common issue around the world, that many, many homes or commercial structures are often in minor or major violations of building codes. Building codes violations do not all have to lead to complete demolition of the entire structures. So, for example, they can be abated or cured by modifications to buildings. There is no need to bring down the whole structure, for example. But as far as I'm aware of, there has not been such an approach to quote unquote curing irregularities, even if there are irregularities. A moment that building is declared to be irregular, the only and blunt way to approach it in India seems to be to send a bulldozer to bring the whole thing down. That to me seems excessive and arbitrary and disproportionate, which actually goes against not just international human rights law, but the concepts of reasonableness in a long line of Indian Supreme Court cases, all the way from Maneka Gandhi to now the most recent cases involving Puttasamy, for example. That restrictions on fundamental rights are okay, but the restrictions themselves have to be reasonable and limited. They cannot be excessive or disproportionate. This has been made very clear by the Supreme Court over the years. So, in a nutshell, I would say there is a real problem in the way demolitions are carried out. They are not consistent with the Indian law, and they are not consistent with international human rights law.
I mean, and like you're saying, the sort of issue with demolitions in India, while punitive demolitions is a more recent and particularly ugly phenomenon, but generally demolitions is an older beast of its own that has prevailed in India for a while. And in that context, in a country that's so invested in quote unquote development projects, quote unquote beautification projects, how do you change the perspective of a state from seeing it as unauthorized constructions or illegal encroachments to seeing it as a issue of adequate housing for all? Like, how do you go about that transformation?
It's an enormous challenge, and India is not alone in facing that challenge. I deal with many countries where countries don't really take the right of people to be secure in their homes seriously as a fundamental human right. They're often quite easily pushed out of the way, often at the point of a gun, or by the use of bulldozers, without any remedies. And as I said earlier about in my remarks about resettlement failures, they're often left to fend on their own. Basically, they are not cared for after the evictions or displacement or demolitions happen either. Now, how do you change that kind of status quo? It's an enormous challenge. But I must believe, I must say that I believe that the first step in addressing any such situation starts with the acknowledgement of the state concern, that there is a need to change the institutional and legal frameworks that apply. So, a fundamental change in the legislative framework is a foundational requirement. In India's case, that starts with recognizing that a home is not just property to be compensated if it is lost. A home is also a fundamental human right. The problem in India's constitution is that under Chapter 3 of India's constitution, the fundamental rights that are guaranteed for citizens, that, for example, can be judicially protected under Article 32, they're all rights, very important rights, but they don't really include economic, social, and cultural rights, such as right to adequate housing or right to food or right to water and sanitation. They're all internationally recognized human rights. For example, under the International Covenant on Economic, Social, and Cultural Rights, which India is a party to. But those rights are not recognized as equal to, say, freedom of expression or freedom of religion. So those protection of a right to access to a home, for example, is arguably a directive principle of state policy under Chapter 4 of the Constitution, but they are not recognized as co equal rights under Chapter 3. And this is a design decision that was made by India's founders in the 1940s. And that is the same position that we are in. And the Supreme Court has struggled over the years about how to deal with housing rights violations when you don't have housing rights that are protected under the Constitution. So, if you go back all the way to the Olga Tellis case, a landmark case in 1980s, to other cases, including Ajay Maken and other cases recently, the courts have tried to read the right to adequate housing by reading it into other enforceable constitutional provisions in Chapter 3. The usual sort of approach that the court has taken in India has been to try to interpret Article 21, the right to life, to try to read that into Article 21. Now, that's a very creative and, I must say, incredibly important approach to protection of human rights by Indian Supreme Court and other courts, which is very important. But the fact remains that, legally speaking, India is actually not fully consistently following the implications of recognizing right to adequate housing or other rights as human rights. They must be better protected legally. Currently, they simply are not. They're not protected under the Constitution. There is no independent statute, for example, that protects the right to adequate housing. There is no law on, say, regulating what is a legal eviction from an illegal eviction. Many countries have those kinds of laws. For example, South Africa has a law from 1998 that clearly defines what is a legal versus illegal eviction. In India, evictions are rampant because the process of carrying out evictions is far too easy, and often irregularities are not really checked because there are no real substantive guidelines for what is the proper eviction in the first place. So we have a pandemic of evictions and demolitions all over India, not just punitive ones, as we have seen in recent years, but a much older, bigger problem, an older beast, as you called it. It has been with us for a long time. And often, in the case of large development projects, like the Narmada project, for example, we find hundreds of thousands of people who are simply forcibly moved out of the way in the name of an alleged public good. And unfortunately, these may have been necessary or important at one stage of India's development and India's trajectory as a state that complies with international human rights standards. But I believe that there is a time to revisit this now. There is a time to rethink the legal framework. But beyond the legal framework, we also have to recognize the importance of approaching the justifications for displacement and demolitions using a different framework of mind when it comes to understanding what quality of life is or what development is. So the if we start with the assumption that development involves taking decisions about collective welfare that actually sacrifice the rights of many in the interests of the so-called public good, then you end up with one approach to development in which it's easy to sort of, justify the violations of many rights. But I believe that with the Sustainable Development Goals (SDG) framework by the UN in 2015 and India's own adherence to that framework, development itself has undergone a fundamental transition. It's not about large projects and increasing GDP growth alone anymore, but people's well-being has to be improved, and people's well-being has to be front and center. That involves decisions that actually clearly prioritize the protection of people's health, people's housing, people's access to clean water, clean air, sanitation, people's access to jobs, while also respecting their dignity and their rights to equality as fellow citizens. Those kinds of goals require different reorientation to development, which I don't think it has happened in India yet. And India is not alone, but I'm just saying that this is a more fundamental problem. So the first is the legal lacuna, but the second is the reframing of an approach to development, to conservation, to variety of public decision making that requires a more careful balancing of what is really at stake.
You mentioned that this reframing has to start with the legal impetus and sort of creating a new foundational law. But right now we already have some notice period requirements, some sort of due process requirements are there. Like you say, they do vary across states, but they are there, and even those have been very quite flagrantly violated time and time again. So, in that sense, I guess my question is: does all this require or assume a bona fide intent from the state? How do you respond to the notion of something like bulldozer justice, which embraces a very different type of law and order and what is right when it comes to demolitions?
Well, bulldozer justice is a maybe a term used by some people in India, but it doesn't really have any grounding in law, whether domestic or international law. It's basically a kind of hooliganism.
Right. But unfortunately, it's a
It's
hooliganism endorsed by the state and with public approval. Like, of course, like not
right,
by
right.
you and I, and a lot, presumably not by the listeners to this podcast, but otherwise widely so, and not just from the, like it's reached a point where the ruling government with the BJP in UP doing it has also prompted opposition parties to similarly call for bulldozers as a response. But that is still accepting that as part of policy rather than addressing that this is not the way we can think about things.
right, right, right. Exactly. Yeah. Unfortunately, that is true. That it's basically a kind of endorsement of a culture of lawlessness to term something as bulldozer justice. I mean, by definition, the use of a bulldozer without legal process can never be quote unquote justice. It's a very definition of the idea of injustice. It's the opposite of justice. Um, so I don't believe that that is an issue that is based or can be defended legally in any way. Now, as far as the procedures that exist are concerned, yes, they are violated very often, whether these procedures are adequate or inadequate. And as I said, they are inadequate from an international human rights standpoint, but even the existing ones are violated quite rampantly. So there is a question of lack of accountability of the state officials when it comes to their failure to follow even the existing provisions of the law. So, for example, if there is a notice period, even those are often violated, or the notices are issued wrongly. For example, in the Kargon case in Madhya Pradesh, in some cases that I looked at, the notice was issued in the name of the male head of household, whereas the property was actually registered in the name of the spouse of the family. So the notice was fundamentally legally wrong, but yet the house was demolished. I mean, I pointed this out in my communication to the government of India, which was 2 years ago. and I have not received a response from the government of India. And this communication is public on the UN website. I believe that the procedures that exist need to be enforced with more consistency by the state. But the question of how do you actually ensure that is a real challenge. And I don't think that judiciary alone can simply make it happen by simply issuing an order. Many judicial orders continue to be either slow walked or ignored altogether in Indian or other governments' bureaucracy. I see it all the time in the US, where judicial orders are constantly slow walked or ignored, for example. So a judiciary alone cannot change the culture of the entire state system. But on the other hand, there are rules that can be in place that make it more costly for state officials to ignore compliance. For example, if a property is demolished, if there is a rule that the site where the property stood, the title or the land use of that particular site cannot be altered unless there is a thorough evaluation of the status of the individuals and to fairly compensate them. That could be a sufficient guarantee, because ultimately, if a home or a set of homes are demolished, but the decision makers cannot do anything with the site that is cleared up. For example, they cannot sell it to another individual, or they cannot lease it to another company, or essentially their hands are tied in terms of what they can do with that piece of land that has been freed up. That might actually sort of send a message clearly that you better follow some procedures carefully here. And I have proposed it in intervention to the Supreme Court. And then the other issue is, of course, also holding individual officials accountable for their failure to comply with rules. I'm not talking about using the contempt power of the court, but to create a statutory framework for not just kind of individual administrative accountability. For example, accountability that is tied to failure to carry out the requirements of the law, that is tied to administrative sanctions or remedies to individuals to proceed against officials, but also to create civil remedies in the form of compensation to individuals, which are recoverable from the assets of the officials themselves who actually are involved in ordering these demolitions. So, for example, if a demolition is found to be illegal or arbitrary, as I have described it, then I don't see any reason why law cannot provide that the officials who are involved in ordering the arbitrary demolitions might be exposed to legal liability by having to compensate the individuals from their own assets. It's not, in other words, a responsibility of the state, it's a responsibility of the individuals concerned. That should at least have some deterrent effect on individuals, because they have to think twice. If I do the wrong thing today, what if I'm proceeded against for my own assets tomorrow?
That would be very interesting if that did exist. And the Supreme Court has reserved its order for judgment in the case, and from what they've stated, that they will be issuing pan India guidelines in the interim. But let's see. I mean, I would be very pleasantly surprised if they do issue that sort of a civil remedy compensation thing as well. Because, like you say, I mean, I think that might be a deterrent, because otherwise the power is entirely right now in the state. And if you rely on the state for the implementation of things, a state that is sort of intent on something like bulldozer justice would obviously not pursue this. But to have something like that in law would empower the victims of these things in a way that right now they are not.
Right. I mean, if you think about the Vishaka guidelines, which were issued by the Supreme Court in the 80s on sexual harassment in the workplace, that finally led to a law on sexual harassment at work in 2012. There are precedents in the Indian Supreme Court of the court issuing guidelines which become very important. They take the force of law and they influence the lawmaking in the future. And if you look at the Vishaka guidelines as an example, it did create a regime of responsibility and lead to transformation in corporate work practices in terms of at least the formal commitment to ensuring a workplace free of sexual harassment. I'm not saying that it doesn't happen anymore. Of course, it continues to happen, but that the framework was changed as a result. And I do think that this is a great opportunity for the Supreme Court to issue a similar set of guidelines to say that uh, creating the rules that guarantee human rights is very important, but making sure that those rules are actually enforced is equally important. Because you can always have a pretty set of rules, but then if nobody follows it, it's of no use. So they have to come up with some creative sort of responses to the what I call as the implementation deficit in India, but also it's pretty much true, as I said, in many countries. They all have pretty laws, but then you look at the reality of implementation, there is a huge gap between law on the books and law in action. When I went to Uzbekistan in August, that's exactly what I found. They have an amazing set of very progressive legislation. But you look at the reality on the ground, it's like an incredible deficit between laws on the books and law in action. In fact, that was kind of my first conclusion during my press conference after the visit.
If I can move beyond the Indian context for a bit, you've been quite a strong advocate for the recognition of domicide as a separate crime under the Crimes Against Humanity and the Rome Statute of the International Criminal Court. Could I ask you to define what domicide is and what would be the importance of such a recognition?
Yes, unfortunately, conflicts are proliferating around the world, and conflicts are increasingly happening in urban areas because simply because more and more people are living in urban areas. The planet is getting urbanized much more. So warfare is not what it was, say, 100 years ago, when during First World War the German and the French armies faced off against each other, across an open battlefield, embankments and and trenches, and they were far removed from cities. But that's not the way war is fought anymore. People live in cities. The command and control centers of military units are based in cities. Infrastructure that is critical for military success is close to or based in cities. So cities are going to be destroyed during warfare. And that's what we are seeing. We are seeing it in Ukraine and Russia. We are seeing it in Gaza, where the whole territory has been pummeled. Gaza was a highly urbanized place. More than 77% of Gazan people were actually living in urban areas. It's not a rural society at all. But then they've been completely obliterated as a an urban environment. And the reason why I call for the recognition of domicile is because of this reality that more and more people live in urban areas, and when conflicts increase, that also means that more and more homes are going to get demolished because we live in urban areas. Our homes get demolished when bombs are dropped or when artillery is used, and we need to recognize the mass destruction of homes as a crime, a standalone crime of its own. And I called it domicide. So the Geneva Convention already calls on military commanders to rely on the rule of distinction, to distinguish between civilian objects and military objects. And civilian objects are quite clear. Homes are not civilian objects. Hospitals are not civilian objects. Schools are not civilian objects. Religious places are not civilian objects. So to justify destruction of those buildings, already the Geneva Convention imposes a higher standard in terms of the necessity, proportionality, and all the other requirements. Now that's in terms of the laws of war. But when an entire neighborhood or an entire city is obliterated, as we are seeing increasingly in conflicts, I mean, almost the entire city of Mariupol was destroyed by Russian forces in Ukraine. The entirety of homes was destroyed in Syria, for example, during the Syrian war. And we are seeing it increasingly in countries around the world. The US, when it engaged in invasion of Iraq, destroyed the entire city of Fallujah. Over 70% was destroyed. This is a very unfortunate sort of issue. And right now, international law has a huge gap in that such a massive destruction of housing across an entire neighborhood or a city is not itself a crime under international law. That's why I propose the recognition of such mass destruction to be a crime under international law called a domicide, and I propose that it be a crime against humanity. Now, why did I say that? And why not genocide? It's because often you find that homes are destroyed on a massive scale, but they are not necessarily accompanied by the intention to actually physically eradicate the entire people concerned. The basic distinction between crime against humanity and genocide is that both involve mass destruction of some sort to a people, but genocide involves an additional element, which is that there must be an intention to eradicate a people in whole or in part under the Genocide Convention. With crimes against humanity, we don't have that. We don't have that requirement. So I do believe that domicide is increasingly happening around a increasingly urbanized planet that we are living on. Wars are increasing, conflicts are increasing. It's very important that we also increase our ability to discourage such wars from breaking out in the first place, but also when the wars do break out, there are rules that are in place to discourage the mass destruction of housing. Right now, it's too easy to do. And we are seeing it, unfortunately, play out in extremely graphic manner in Gaza, for example, about which you know, myself and many others have spoken in the UN system quite openly. So that's basically the reason why we have the need for recognizing domicide. But I must also say that because I call for domicide to be recognized as a crime against humanity, the idea is to also include the possibility of holding people accountable when they are responsible for mass destruction of housing, even during so-called times of peace, meaning, for example, through, say, development projects or through other measures when entire villages or towns are obliterated, then it might very well raise concerns about whether an act of domicide is being created. I do deal with those cases all the time. For example, one case that is I've mentioned briefly that is in the public domain involved a communication I sent to the government of Saudi Arabia for setting up this new city that they're building called the Neom City. But to build that city, they had to actually violently demolish the homes and displace 30,000 members of a tribal community called the Al Howita tribe. Their homes were completely destroyed. They were being moved elsewhere, and their way of life has been obliterated. As a people, it's an indigenous group. They had a right to live on their land, and also people who attempted to express an objection or protested have been dealt with extremely harshly, including by charging them with crimes of terrorism and punishing them to death using judicial proceedings that simply don't live up to global standards. So it's a real issue. Countries can go around destroying the homes of 10,000, 20,000, 50,000 people, all in the name of quote unquote beneficial intentions. And I do believe that we need to actually start paying closer attention to those.
That's quite interesting. Even the example you gave specifically, because part of the thing, like something I found quite interesting about what you've said about domicide is one that it doesn't need to be in an armed conflict, unlike other things under the Geneva Convention or under war crimes in the Rome Statute. And two, you've spoken about how domicide and the destruction of homes is not just about that property, but about a destruction of memory and collective memory and culture. And we see that destruction of culture and memory in all the punitive demolition in India. And like at the project at Polis Project, we have a demolitions research project, and that's part of the idea is also to sort of cover and look into those elements of the destruction of memory. But in international law at current, is there any recognition of that? I mean, I know domicide there isn't, but this idea of violence or sort of action, state actions targeted towards destroying collective memory or destroying culture, is that something that's recognized?
It is increasingly beginning to be recognized. We find, for example, some legal instruments created under the auspices of UNESCO, for example, to protect the intangible properties of indigenous people, or in fact aiming to protect not just material interests, but non material interests, including the value that people put on particular intangible sort of practices as well. The rights of indigenous people, including under the UN Declaration on the Rights of Indigenous People, does recognize the quote unquote attachment of people to their own land as an independent legal interest to be protected. In other words, it's not the property value in the land alone that is protected, but the actual emotional and non material attachment of indigenous people to their land is actually protected under international law. So that is clearly an increasing recognition of the importance of sentiments that people have, that they also deserve to be protected as well. As far as the remedies are concerned as well, we increasingly see that there is an approach to adopting the framework of reparation as opposed to compensation as a way to deal with losses of human rights, such as right to adequate housing. In my case, I myself have recommended that it's one thing if an individual loses a home, which is itself a terrible loss. If they own the property, not only there is an economic loss, but there is a loss of memory and attachment and emotional connections that they may have had with that home, because that's where they have the memories of doing so many things that gave them value, including celebrating functions, or holding events, or meeting with people, or just intimate moments with their own loved ones. Homes are where people have memories. Of course, it's a loss. But when it comes to not just an individual losing a home, but an entire community losing their homes, as in the case of, for example, the Al Hawita tribe in Saudi Arabia that I mentioned, then what you're looking at is basically an act of trauma. The community is going through a trauma. They're collectively mourning what they've lost very often. And I find that very often, when I speak to communities that have been affected, that is quite true. That is exactly how they feel it. For example, I was in Netherlands for a country visit last December. One neighborhood in the city of Rotterdam that had been slated for demolition was unfortunately demolished 2 years ago, despite my official intervention and my attempt to try to prevent it. That neighborhood was demolished, and the entire population was scattered around, the rest of Rotterdam and Netherlands. But when I visited the place again to see what had become of that location, the community that had been scattered heard about my visit and they reassembled to meet me. And one of the first things that came out of that meeting was the collective sense of loss that they felt as a community. There is a trauma that they're still going through 2 years on. Many of them are on the verge of tears, for example, describing the utter humiliation that they felt at being treated like they don't matter at all. Their voices were utterly unheard. And I mean, this is not possible to address just by giving them money. It's a bigger issue that we are seeing, and we need to sort of recognize that as part of human rights. And that's why a trauma informed approach to loss of human rights is a very important part of a reparative approach to human rights, as opposed to an approach that relies on financial compensation alone. So, for example, that has implications for, say, demolitions in countries like India. So, if we look at even the very progressive 2013 land acquisition law, which is an enormously progressive law that rightly replaced the colonial 1894 law on land acquisition in India. But even if you look at it, it deals with the loss of land or housing as simply an issue of compensation. There is really no reparative approach in that law either. So I mean, it's just that we need to start sort of increasing the expectations of what we must do, when countries go through the, I mean, when communities go through the trauma of losing their entire way of life.
Yeah, that's quite an interesting idea also, that sort of trauma and informed approach is not something that seems to be at all in the general discourse on these things. But if I could go back to domicide, and I think in that context, I really have to, and we should speak about the ongoing genocide in Palestine. Um, One of the things that you've talked about is that, in specifically while talking about the domicide in Palestine, is that the scale of destruction that's there right now is the worst that you've seen, even sort of going as far back as World War II. Thinking about the UN as an organization sort of formed from the ruins of World War II, and now these many years later, we are at the stage where we are seeing the worst scale of destruction we've seen. What does that really then say about the UN or international institutions? And in that sense, even if domicide were to be recognized as a crime, would we just be debating whether or not this amounts to domicide or not while Israel continues its domicide?
That's a very legitimate question, and I must say and along with many other UN rapporteurs, we are very concerned that the international order is on a knife's edge. It's like a fork in the road at this point. One road leads to a slippery slope of further sort of destruction of the world order that was built after 1945, and the systematic sort of violation or neglect of the rules, including international law that protects human rights, that was created. The other route actually involves a determined attempt by the rest of us to try to protect what was important and good about what was built, and then acknowledge the problems and defects in that framework as well and try to improve them. As I said, for example, by recognizing that there is a need to recognize a crime such as domicide. So the system was not perfect, but it did a lot of good. And it's important not to lose sight of that. And unfortunately, there is a very short sighted approach to the central accomplishments of the international system during the last 70 plus years. And I'm along with many others are very very concerned about where we are and what we are facing. I hope that that is recognized and we come up with a different approach. So recently, for example, the General Assembly considered the convened the Summit of the Future and adopted something called the Pact of the Future, which is partly kind of an attempt to acknowledge that we are at a moment when we must really renew and reiterate our commitment to solving our mounting problems, and we have too many problems coming from too many directions. There is armed conflict, there is climate change, there is financialization, there is increasing divisions within societies. It's a real critical moment, and we need to renew our commitments. We need to be innovative and determined to pull ourselves out of it at this point.
In the context of domicide in Palestine, you've also talked about how not just recently in Gaza, but the West Bank has seen a decades long sort of consistent, systemic, and systematic homicide been ongoing. And how that is in the West Bank, you sort of see it and phrase it in the context of punitive demolitions as well. So I want to ask you, apart from India and the West Bank, do you see punitive demolitions as a common thing elsewhere in the world as well in your work? And two, specifically with India and Palestine, what are the similarities and differences in how punitive demolitions play out?
Punitive demolitions, of course, have been most prominently associated with two countries at this point. In fact, only one country, which is Israel. Israel has pursued punitive demolitions as an act of occupation, as a tool of occupation, and as a tool of annexation in the West Bank, in particular. Denial of home permits, first of all, to existing Palestinians who want to build anything at all. And secondly, on the flimsiest of reasons or for no reason at all, ordering home demolitions, including as a punishment for a charge that somebody in that house might have been involved in something very simple, like say somebody from that house ends up throwing a stone at an Israeli military vehicle, their home might get demolished. So this is been practiced for years in Israel, and the only other country that is increasingly adopting it as state policy that I am aware of is India. In other countries, we have arbitrary demolitions, but not punitive demolitions in the way in which we have seen in Israel and in India. Although in individual cases, I have seen examples of punitive demolitions. So, for example, I know that human rights defenders in countries where they have spoken out, sometimes actively on issues, they are singled out and their homes have been demolished as a punishment. And this has happened in many, many countries. And in fact, I've intervened in some of those cases as well. Those examples are everywhere. They are in Europe, they are in Central Asia, they are in Africa. I've intervened in all of those cases. But an entire community getting targeted and their homes getting demolished as a punitive demolition is something that we've seen in Israel and then now in India. But having said that, the other thing I would say is that demolitions, punitive demolitions, have been carried out as part of counterinsurgency warfare for years. For example, during Vietnam War, the U.S. regularly burned down entire villages on the mere suspicion or as a punishment for somebody in that village being part of the Viet Cong. We have seen that in the during anti-colonial wars. For example, the British campaign against Malayan insurgents in what is now Malaysia, or against the Mau Mau in Kenya in the 1950s. They all engaged in collective punishment of entire communities because one or two individuals from those communities were suspected to be involved in rebelling against, colonial authorities. So we've seen that in counterinsurgency warfare for a long time, but just that in peacetime, in the outside of the context of counterinsurgency, we are seeing, well, technically, Israel is not, quote unquote, at peacetime because it's also a situation under military occupation. But in entirely peace times, we are seeing it happen in India. Perhaps that's a unique sort of unfortunate development that we are seeing.
I understand that India's is a lot more recent and not at the same scale as Israel's. But would you think India is committing domicide right now?
I think it may be that certain past examples of collective or indiscriminate or mass destruction of housing may qualify as acts of domicide. For example, in the context of specific development projects, we have seen mass destruction of many, many villages, the collective destruction of their entire households, and the collective removal of those communities. Those might very well have constituted acts of domicile, but in terms of what we are witnessing right now in states like Uttar Pradesh, Madhya Pradesh, in Gujarat, in Delhi, what we have seen, those are still at the level of individual home demolitions that don't quite reach the scale that we can think of when it comes to those acts becoming acts of domicide yet, but they are grave human rights violations.
Especially with respect to India and Israel, but also more broadly, I suppose. How do you hold deliberate and strategic violations of international human rights law, international criminal law to account?
Well, that's a $1 million question about how do you hold states and individuals to account. And it has long been a struggle. It's been the central, one of the basic issues of international law. How do you hold states and individuals accountable? The legal frameworks that we have created over the years, including criminal tribunals, first ad hoc tribunals, and now the Permanent International Criminal Court, the functioning of judicial bodies such as the International Court of Justice, the accountability mechanisms through the UN system, including the General Assembly and the Security Council, which are collective decision making bodies after all. They were intended to put in place a mechanism to hold states and individuals accountable. But we are very, very far from realizing the basic potential of those mechanisms. I also believe strongly that accountability should come not only from outside, from the top, or from the UN or whatever, but they must bubble up from below. They must be internally generated. And the capacity of people and institutions within countries to demand accountability, to behave in a manner that is consistent with international law, is extremely important. That involves creation of a population, first of all, that expects better from their own states and their decision makers, that is capable of understanding and expecting more from international law, that is not averse to international law. Like, for example, in the country where I live, in the US, there is a kind of a US centric approach to thinking about things that often doesn't really allow even well intended groups of citizens to even realize the potential of using international mechanisms and international law. So there are cultural problems, there are perception problems, there are legal, domestic legal, and other issues. But basically, the point I want to make is that accountability is a process of constant demand and mobilization. It's not a one time occurrence. It's not that you can create a system and after the creation of a system, there is going to be something called accountability forever. That's not how it works. Accountability is continuously to be demanded because it will always be resisted. So it has to be constantly demanded, constantly mobilized for, and then you have a chance of making it happen over the years. So it's always a work in progress.
All right, we'll leave it at that. Thank you so much, Mr. Rajagopal. It's been a great chat. Thank you for your time. And yeah, let's see what happens both in the Supreme Court, and I have, I think, lesser hope for the general accountability. I mean, we've seen this sort of, especially when it comes to Palestine, you've seen that ground up resistance so much, but still, it's been like a brick wall, really, that's not breaking. But thank you so much for your time.